one of the core components that we've seen with the development and the actual success of digital health technologies is intellectual property. As you all know, going back to e-prescribing in the 1990s, that made one particular company and one particular person many hundreds of millions of dollars when they patented e-prescribing. The idea of intellectual property is critical to not only protect what you're developing, but also to make sure that whether it's the Netflix and one-click subscription kind of idea, rental by subscription idea, or whether it's e-prescribing, that your idea is protected and it can actually grow without being encumbered or somehow copied by some other firm. And so David Lee is here today, and he's going to give us a one-on-one on intellectual property for all the startups in the audience and even the bigger institutions who are trying to still work through how intellectual property is a part of their idea and a part of their growth. And obviously, even if you're an institution, you need to have a good understanding of how intellectual property battles could affect how you're actually working through and purchasing this stuff, because you don't want to buy a piece of technology that's encumbered in lawsuits because of some kind of intellectual property dispute. So on that note, handing the virtual microphone and podium over to David Lee to give us some lessons in intellectual property. David.
Stan, thank you for having me. So thanks for the opportunity to discuss the IP protection today. I'd like to share some slides with everyone. I think it's the best way to demonstrate the role of IP for healthcare startups. And I hope this works.
Perfect. Yeah, you're sounding good. You're looking good. And then we just we'll wait for the screen share. And again, for anyone in the audience that wants to connect with David, please do click on his LinkedIn as well, which will be a great way to message him with any comments or questions or anything like that. But yeah, there we are seeing your screen. You're good to go.
Okay, wonderful. All right. So just a little bit about myself. I've been in the IP industry for about 20 years. I'm a patent attorney. During that time, I've represented a number of companies in the healthcare industry in all aspects of intellectual property, including obtaining patents, litigating or defending against patent litigation, as well as licensing. So today, I'd like to talk about three topics for healthcare startups. The first is, what is IP protection and how does it work to protect your company? Second is, what should a healthcare startup keep secret and when is the right time to pursue a patent? And the third is, why having some IP protection is better than none. Now, IP protection, IP refers to a number of different things. Mainly patents is what people have in mind, but also trademarks, copyrights, and trade secrets. I'm not going to go into what those are today, but because I think it's more helpful for us to discuss what the best way is for healthcare startups to think about IP. And so what is the main role of IP protection for healthcare startups? Is it offensive or is it defensive? Now, there is a common perception that IP is offensive, and it's understandable. We hear about lawsuits between Apple and Samsung, all sorts of companies filing patent lawsuits against each other, and the impression is that IP is offensive. But in reality, for a healthcare startup, the main role of IP protection is mainly defensive. And I like to use the analogy of a soccer goalkeeper. It's actually a pretty good analogy, and I'll explain why. The main task of a goalkeeper is to protect against competitors scoring on your goal. And that is exactly what the perspective ought to be for healthcare startups in thinking about IP protection. Now, on rare occasions, goalkeepers do score goals against the other team. There are some amazing videos online about that, showing that, and I encourage everyone to take a look. But it's very rare. Using that analogy, now how rare is it that patents get asserted and litigated against competitors? Statistics show that really only 0.11% of active US patents are ever litigated. So what this means is that if a company has 1,000 patents, only one will ever be litigated, asserted. And if your competitors have 1,000 patents, only one of them will ever really potentially be litigated against you. Now for a healthcare startup, 1,000 patents is just would be phenomenal. Most healthcare startups are looking at somewhere in the range of 5 to 10 patents, which means that if 0.1% of those patents are ever litigated, the chance of using patents offensively is very small. So why bother with patents, or why bother protecting against such small percentages when it seems unlikely that patents would really ever be litigated? And the answer is because litigation costs are enormous. These statistics on the screen now are from the American IP Law Association. They're a bit outdated, but they do illustrate that for patent lawsuits where there's less than $1 million at risk, what the patent litigants can expect is to spend at least $50,000 on that litigation, up to about $700,000 total. And these are just litigation costs. They don't involve cost of damages in case the company is found liable for patent infringement. They don't involve settlements where licensing fees and royalties may have to be paid. It only goes up from there. If the patent litigation involves $1 million to $10 million at risk, the parties can expect to spend anywhere between $80,000 to $1.5 million. And the numbers just go up from there when there's more at risk. And nowadays, 5 years later, these numbers are only higher. So the way to think about IP protection as a healthcare startup is to think about it as protecting your company against catastrophic risk. Using the soccer analogy, you can't block every shot on goal, but you should block just enough to stay in the game. And how do we do that? First is to understand the extent of the competitor's IP. Now, for your competitors, what do they have? Do they even have any IP? And if they do, how extensive is it? Then from there, determine the risk that IP poses against your company. If there's nothing out there, then it's minimal risk, potentially. If there's a lot, then it poses a lot of risk. And then from there, develop and implement a defense strategy to reduce that risk. Now, not everybody needs a professional goalkeeper, but sometimes on the right over here on the slide, a starting point is enough. Second topic, what to keep secret and when to patent. This is a very important question for healthcare startups because on the one hand, there is a desire to publish and get the word out about the new product, the platform, so to attract customer base, attract public interest in it. On the other hand, there's some worry that disclosing too much may allow others to get in on the new innovation and perhaps develop a competing product. One thing that many people think about when it comes to IP is filing patent applications, as I mentioned, as an offensive strategy. Patent applications are intellectual property that you can assert against others who may be trying to copy your product. But what I like to encourage is to think about patent applications as a defensive strategy. As we saw before, really only 1 in 1,000 patents are ever litigated. So really, patent applications are mainly a defensive tool. And now, how does that work? First is an earlier patent application that's filed can prevent later ones from becoming patents. Second one, a granted patent can usually deter competitor lawsuits if your granted patent also covers one of their products. And the third is, as a defensive strategy, patent applications are great for balancing confidentiality with IP protection because patent applications are confidential for 18 months. What exactly should you keep secret? And this is a question where we almost have to answer it in negative. And the 3 main points are information that's not needed by regulators, customers, investors, or clinical trials are information that are candidates for being kept secret. If you have any product algorithms that implement, for example, in the cloud, where competitors simply cannot access and reverse engineer it, that's also something that you can keep secret. And lastly, information that you won't need to publicize for advertising or marketing purposes, or that you won't be publishing to build credibility for your platform or tool, that's something that you can keep secret as well. On the flip side, when is the right time to file a patent application? Now, definitely before you disclose any information publicly or to really anyone else outside your company, that's the best time to file a patent application. So before disclosing information to regulators, customers, investors, or for clinical trials, before publicizing product features or capabilities, and ideally, the time to file a patent application is when the design for a product feature or for a product is settled and implementation details would simply be routine. So you don't need to have implemented a product. You don't need to have engaged a coder or manufacturer. When the design is settled and implementation is simply routine, that is a good time for a patent application. To conclude, some IP protection is better than none. This slide here illustrates an analysis we did, a fairly rough analysis of exactly what proportion of patent applications between 1970 and 2020 in the healthcare space were filed by large companies such as S&P 500, NASDAQ, or Dow companies, and which ones were filed by others. And the blue line here shows all patent applications filed in the space in that 50-year span. The gray line at the bottom shows the ones that were filed by the very, very large companies, and the line in orange shows that other companies, which are not as large and not public, also have a significant involvement and role in filing patent applications. So patent applications are not just for, and IP protection, it's not just for large companies, it's for startups as well. There's always a right strategy for every healthcare startup. Cost is a main issue, and when international patent protection comes into play, cost is definitely very significant. One example of cost timing as a strategy for a healthcare startup is to, for example, if you file a patent application today, you can file it as a placeholder with fairly low cost. Within 12 months, you'll then need to file an international placeholder, assuming that's the right strategy at that time, to continue with placeholders at a slightly larger cost. Then at the 30-month period, which is about 2.5 years, that's when the significant costs start to roll in. And then every about a year and a half after that, there will be recurring costs as well. So there is a strategy where costs can be deferred and spread out over time. And if that's the right strategy, then it's simply a very viable one to defer costs for IP protection. So I like to use this slide again because it's very useful, but I added it and revised it in a way in a little bit just to say that, you know, not everyone needs a professional goalkeeper right away, and sometimes starting with a small one is enough to start. And that's it.
Amazing. Well, I don't know about the audience, but I've done a lot of work helping out folks like yourself. I just learned a ton. So thank you very much, David. That's a great presentation.
My pleasure. Thanks for having me, Stan.